Good evening. I'm attorney Mikal Watts, and this is a presentation for you, your company, your general counsel, and your lawyers to watch concerning the tariff recovery litigation. In this 45 minutes or so, I'll explain to you how to help your importer clients get back the tariffs that they paid to the Trump administration, which total $166 billion. So at this time, I'll begin to take you through a PowerPoint I prepared to help you understand what this litigation is about and how we intend to proceed. Let me start off our discussion with the truism that this is not a political attack on the Trump administration's use of tariffs. Indeed, when he ran for election in 2024, he said he was going to use tariffs as part of his international policies, his foreign policy, and his fiscal policy. And he did precisely what he said he was going to do, but it's the manner in which he did it. The bottom line is that this lawsuit is about the separation of constitutional powers with statutory delegation of those powers, because Article 1, Section 8 of the United States Constitution puts the power to levy tariffs with the Congress and solely with the Congress. And it stays with the Congress unless the Congress, by way of statute, delegates that authority to any third party, in this case to the presidency. And so what this case was about is the interplay between Article 1, Section 8, which said it's Congress's power unless they delegate it. And the question was, under the International Emergency Economic Powers Act, did that delegation statutorily occur? That statute is found at 50 United States Code, Section 1701 through 1706. It's part of the War and National Defense section of Title 50, Chapter 35, dealing with the International Emergency Economic Powers, and the specific act, the International Emergency Economic Powers Act, is found at 50 U.S.C. Section 1701 through 1706. I'll take you through 5 different things tonight, and first of all, we're going to talk about President Trump's tariffs and his use of the International Emergency Economic Powers Act, known as IEEPA, I-E-E-P-A. With respect to the IEEPA, it's one of 5 kinds of tariffs he could have done. There's Section 232 of the Trade Expansion Act of 1962 that allows him to levy tariff if he finds that it impairs national security. And then we have the Trade Act of 1974. He had available to him temporary tariffs under Section 122 if he found that there was balance of payment deficits. In other words, an inadequate export versus import, a trade deficit, which we clearly have. He had the ability to issue tariffs for 150 days under Section 122. And then there's Section 201 of the same act that allows him to issue tariffs if he's going to safeguard against serious injuries, but there's findings that are required before Section 201 tariffs can be issued. Section 301 tariff requires findings of unfair practices versus United States commercial interests. Again, findings are required under Section 301. But what President Trump did is he issued tariffs under Section 1701A of the International Emergency Economic Powers Act, or IEEPA, of 1977. But this required a finding of unusual and extraordinary threats. And the question was whether this IEEPA was appropriately used by President Trump. Now, what we all heard these tariffs were going to be, these IEEPA tariffs, were so-called reciprocal tariffs. And those were issued by President Trump under Section 1701A of the IEEPA. Was that legal to do? Well, you have to go to IEEPA and see whether or not Congress delegated to the president the ability to issue reciprocal tariffs in the manner that he did. Now, this was amazing in terms of its scope and the sheer power of what President Trump did. He began these tariffs early in his administration in the spring of 2025. By October of 2025, IEEPA tariffs of over $133.5 billion had been levied. That was approximately 60% of the $223.8 billion of total tariffs that were issued under the 5 statutes that we talked about. So IEEPA tariffs were the overwhelming majority of everything that President Trump did. Now, again, this is not an attack on President Trump. He very effectively targeted potential tariffs and issued threats to countries across the world that said, if you don't come to trade deals with the United States to, in his view, remedy the unfairness of international trade that led to this trade deficit, we're going to issue these massive reciprocal tariffs. Now, what did that lead? Well, in just 1 year, according to the Trump administration, he secured over $10 trillion in private and foreign investments in America. And you can see in the New York Post and, protestations from the administration, the biggest day of trade of all time, where there were deals done with the Philippines and with Japan and other countries. Japan itself agreed to invest $550 billion in the United States, a massive win for the Trump administration. He saw similar trade deals with the United Kingdom, with Vietnam, with Indonesia, with Philippines, with Japan, the European Union, and South Korea. All of them agreed to trade deals that were negotiated by the administration to invest dollars in the United States, as opposed to paying these very large reciprocal tariffs that were being issued under the International Emergency Economic Powers Act. Now, what did that result in? In 2025 alone, the Trump administration collected more than $200 billion in tariffs. And on the right side, you can see that the largest states, California, Texas, Florida, paid most of those tariffs. New York, Illinois, Pennsylvania, Georgia, and North Carolina were fourth, fifth, sixth, seventh, and eighth, largely as a function of population. But you can see the relative input of where these tariffs were paid. The charts are overwhelming, and these are all pulled off of various sources on the internet, but you can see that we saw tariffs administered unlike anything we had seen in decades. This was the largest use of tariffs by any administration in 70 years. This caused, for the first time since the 1950s, tariffs percentage of total federal revenues to reach over 3%. That hadn't been done since the 1950s. So again, this was a massive alteration of fiscal and international foreign policy by use of tariffs that was used by President Trump under the IEEPA statute. Now, who paid these tariffs? Well, those against them would say that we did. The American taxpayer, in buying goods and services, we're going to use, according to conservative estimates, about $1,300 per household in the United States. That's what we each were going to pay. Others, including Forbes magazine, said that this could approach $2,400 per household that's coming out of pocket to pay for the added costs of these tariffs. People against them said they were inflationary. But again, that's not what this is about. This is about, were they legal? Well, there's a case called Learning Resources and VOS Selections Incorporated versus Donald J. Trump that tested the legality of these IEEPA tariffs that President Trump levied. And how did it start? Well, there were a couple of lawsuits filed, one in the United States Court of International Trade and one in the United States District Court in the District of Columbia. On 2 consecutive days, May 28th, 2025 and May 29 of 2025, the Court of International Trade, in an en banc decision, and U.S. Federal District Judge Rudy Contreras of the District of Columbia both ruled that the IEEPA tariffs were not legal. Now, both of those were appealed to the Federal Court of Appeals for the Federal Circuit. And on August the 29th of 2025, in a combined ruling affecting those lower court cases, this United States Court of Appeals for the Federal Circuit issued an en banc ruling affirming the lower court's ruling that these IEEPA tariffs by President Trump were illegal. So what did President Trump do? His administration took all of these holdings, which were remarkably consistent, on the 28th, 29th of May and August the 29th, and they all in effect said that Congress has the exclusive power to impose tariffs. And the question is whether, under the International Emergency Economic Powers Act of 1977, Congress delegated those powers back to the president. And all 3 courts, both the lower courts and the Federal Circuit Court of Appeals, said that that had not been done under IEEPA, and therefore President Trump's use of IEEPA tariffs was illegal. He appealed this to the United States Supreme Court. And on the left, you see the court building. On the right, you see the 9 justices who are on the court presently. And they put this under an expedited consideration. They granted certiorari on September the 9th. They put the parties through their paces and ordered almost immediate briefing. Opening brief on the merits 10 days later by September the 19th. Responsive briefs. Or amicus briefs 4 days later. Responsive briefs were due by October the 20th. Amicus in support of the tariffs were due by October the 24th. And reply briefs were going to be due by October the 30th. This was all to set up oral arguments in November. So the court puts us on a tremendous fast track because it was a decision that was going to have enormous input on this country. By November the 5th of 2025, three outstanding appellate court advocates argued the case in front of what I call the High Nine, or the Supreme Court of the United States. Pratik Shah represented Learning Resources. Neil Katyal represented VOS Selections Incorporated. He was a former Solicitor General of the United States, who is in effect the administration's lawyer before the High Court. Well, now he was going against this administration's lawyer before the High Court, Solicitor General John Sauer. And what happened on November the 5th of 2025 led me to believe overwhelmingly that the percentages were high that the Supreme Court was going to agree with the lower courts and hold IEEPA tariffs illegal. How do we do that? Well, you can count. Out of 9, you need 5, and there were clearly 5 votes to affirm. The administration was relying upon a case called Dames and Moore, and the Chief Justice of the United States, who ended up writing the opinion, in effect said that Dames and Moore didn't say what you're trying to get it to say. And so the bottom line is they've claimed a source of IEEPA that had never been before used to justify the tariff. No one had ever argued before that it did until this particular case. So it felt like they didn't have the Chief Justice. Next is Justice Amy Cohen Barrett. And she, in effect, said, can you point to any other place in the code or any other time in history where the phrases that was being used by the administration was used to confer tariff-imposing authority? Can you identify any statute that used that phrase to confer tariffs? And the bottom line is she's a strict constructionist, and she goes with the words of the statutes, and she couldn't find any words in IEEPA that gave the administration the power it claimed to have. And so that seemed like there were 2 votes against the administration. And then Justice Sotomayor, in effect, said she didn't understand the argument of the administration. It's a congressional power, not a presidential power to tax. And you want to say that tariffs are not taxes, but that's exactly what they are. Counsel, we've never applied it to foreign affairs, but this is a tariff. This is a tax. So the bottom line is Sotomayor was hardly subtle in her disdain for the administration's position. Then Justice Jackson, the newest justice, she found inconsistencies at saying we're having to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority. And she pressed the Solicitor General very hard. How can you even disagree with that? So it looked like there were 4 votes. And then Justice Kagan piled on and said, well, crucially, it doesn't have anything in here referring to raising revenue. It has a lot of verbs, a lot of actions under the statute. It just doesn't have the one you want. And so they said they've had recently cases that dealt with the president's emergency powers, and it turns out that we're in emergencies all of the time, like over half the world. So she expressed her disdain for the administration's position. Right there, you have 5 votes against the administration. Importantly, Justice Gorsuch asked not one question during oral argument. And that is very telling because he's usually very engaged. But both Justice Barrett and the lawyer for those folks trying to take out the tariffs were trying to appeal to Justice Gorsuch. Mr. Katyal specifically referred to Justice Gorsuch's dissent in trying to peel off, and Justice Barrett referred to Justice Gorsuch as well. So it was clear that Justice Gorsuch's case was the vote, in effect, in play, and he would be the 6th vote. I still don't know how the administration was going to get to 5. It was clear to me that Justice Thomas was pitching softballs to the Solicitor Generals, spend a few minutes on the major question doctrine, which was a key issue in the case. Justice Thomas said the other side is going to argue with respect to delegation, and so he was obviously going to vote with the administration. Same with Justice Alito, went to the bare statutory language, said it imposes a fee, and so it looked like, as he often does, Justice Alito was going to side with Justice Thomas. And then obviously Justice Kavanaugh ended up writing the opinion in the dissent, and he said, in effect, that he was with the administration. And so it looked like a 5-4 or a 6-3 decision against the administration. It turned out to be a 6-3 ruling that came down on February the 20th of 2026, a major opinion that the president was very unhappy with. But the bottom line is that the 5 that I predicted, and ultimately the 6, said the following. The president asserts the extraordinary power to unilaterally impose tariffs of unlimited amount, duration, and scope. In light of the breadth, the history, and the constitutional context of that asserted authority, he must identify clear congressional authorization to exercise it. IEPA's grant of authority to, quote, regulate importation, close quote, falls short. IEPA contains no reference to tariffs or to duties. The government points to no statute in which Congress used the word regulate to authorize taxation. And until now, no president has read IEPA to confer such power. We claim no special competence in matters of economics or foreign affairs. We claim only, as we must, the limited role assigned to us by Article 3 of the Constitution. Fulfilling that role, we hold that IEPA does not authorize the president to impose tariffs. That was the legal holding of 6 of the 9 justices on the United States Supreme Court. And that happened on February the 20th. So what was the president's response? Well, obviously, the president does not like to be told no. He was angry. His entire foreign policy with respect to tariffs, because he used so much of that tariff power with IEPA, was in effect struck down. Now, interestingly, on the same day, he said, I'm going to immediately announce 10% tariffs on all imports with higher rates from some countries. And nobody can understand, hey, the top court in the land just struck down your ability to do tariffs, and here you are doing it again. This was not a presidential thumbing of his nose at the Supreme Court. He was saying, I have different authorities, and I want to talk to you about what those are. Well, obviously, the IEPA tariffs were struck down, but he still had available to him Section 232, Section 301, and Section 201 of the Trade Act of 1974. But he chose not to use that yet because they require specific findings that he has not made. Instead, what he did is he went back to the Trade Act of 1974 and under Section 122 made a finding that there's a balance of payments deficit, which is not hard to make because we have these enormous trade deficits because America is the best economy in the world. It consumes more than it exports. It imports more than it exports. So it has a balance of payment deficit with most countries in the world. Using that authority under Section 122, he issued almost worldwide 10 to 15% tariffs. Now, the shortcoming of that is he can only do that for 150 days. So he has, in effect, 5 months to have 10 to 15% tariffs across the world unless Congress, this Congress, which has majorities of his party, in effect expands the tariff authority that he's ever been given from back in the 60s and 70s. And so that's what we're going to have to wait and see. But the bottom line is that this political response to the Supreme Court ruling doesn't change the reality that $166 billion of IEPA tariffs issued in 2025 and until February the 20th of 2026 were illegal. So Trump's response, it was twofold. Number one, to order temporary tariffs. And so the IEPA-based tariffs ended on February the 24th, and the temporary tariffs under Section 122 began that same effort. But again, he only has them for 150 days. So that's the first thing that he did, and that's his right, and I'm sure that'll be litigated, but I think the president has that power for 150 days. The second thing he did is he said, look, the Supreme Court didn't say I have to pay them back, and so I'm taking the position that these companies are not going to get these refunds. That's what he originally said. If you just read the articles, you can read the titles and see where we are. The looming chaos of tariff returns. The Supreme Court tariff ruling to spur chaotic refund process. The Trump administration says it could take years and additional litigation for importers to get their money back. The Trump administration wrongfully took $160 billion and now won't give it back. Trump's latest tariff flip-flop, opposing refunds after promising them in court. The Trump administration is looking for ways to keep revenues from tariffs that were ruled illegal after telling the courts that refunds would be easy. There's a Times opinion, Donald Trump's tariff refund game to deny, delay, and defy the Supreme Court. The Trump administration warns that tariffs refund process will take time. And so that led small business owners to doubt that they'll ever get the refunds, even after the Supreme Court invalidated President Trump's tariffs. And so people ask the question, will consumers and businesses ever see refunds for tariffs? The businesses are more likely to win their cases, but receiving a refund could end up taking years, according to legal experts. And then last title, sore losers at the Supreme Court. The government doesn't want to pay back unlawful tariff money after all. To say that litigation against this administration will be necessary, all you have to do is look at what their words have been and what their actions are, and that's where we are. So, where are the importers who are entitled to these IEEPA tariff recoveries? Well, there's two different ways to look at that. The types of imports that have been subjected to IEEPA tariffs, there's many different types, but the top 14 would include food and produce imported from foreign countries, clothing and textile, auto and car parts, chemical products imported, phones, chips, enormous, fabricated metals, furniture, leather goods, lumber and wood, primarily from Canada, but also from other areas in the world, industrial equipment that's imported, medical devices, oil imports, massive quantities, medicines, plastics, and there's many others. So all of these different industries that are known to be heavy importers from foreign countries were subjected to IEEPA tariffs that we believe now are entitled to get their tariffs back in a refund. Now, where were these tariffs collected in effect? Well, IEEPA tariffs were collected by the United States Customs and Border Patrol, what I'll call CBP, at the time of importation, primarily through CBP's electronic systems at ports of entry where the boats come in, at airports where specialty goods are flown in with cargo planes, and at land border crossings, primarily in Canada, and Mexico, where trains are bringing this across pursuant to statutory authority. All three of those sites are the sites where these tariffs, these IEEPA tariffs, were in effect collected by the U.S. Customs and Border Patrol, or CBP. Now, in terms of statistics, there's a difference between the volume of what's being imported and the relative value of that. And so we'll talk about that. First of all, with respect to ships, they bring in almost 80% by weight of all imports into the United States, but only 43.1% of the total value of goods imported into the United States. And the reason for that is that cargo planes by weight bring in less than 0.5% of all the imports, but these are perishable goods, refrigerated pharmaceuticals, products that require a lot of specialty. They're more expensive. And so even though only 0.5% of the weight of total goods was flown in, almost 30% of the total value was flown in. And of course, tariffs are levied as a percentage of value, not a percentage of weight. And then lastly, we have all the trains that are coming across from Mexico and down from Canada, about 20.4% of the weight and about 27.4% of the total value of U.S. imports. So let's look at each of those. First, the ships. Again, 43.1% of all value of what was imported in 2025 and 26. So where are the largest ports? Los Angeles, Long Beach, New York, New Jersey, Houston, Texas, Savannah, Georgia. Those are the top 4 and 5 in terms of 20-foot equivalent units, or TEUs, that were imported into major U.S. ports. You don't have to stop at those 4 or 5s. Here are the locations on the right of the top 25 container ports based on 20-foot equivalent units, TEUs. That's 2020, but it's very similar in 2025 and early 2026. Now, where do the cargo planes come in? The answer is everywhere, but there's primary locations where these levies were in effect, where these tariffs were in effect levied, about 29.5% of all value. Interestingly, a lot of that's coming through Anchorage International. Now, why is that? Because Anchorage is very lowly populated. It's really planes that are flying in from Asia that have to stop for gas. That's the first place in the United States where it touches down, and therefore the tariffs are levied at that point. We also have Memphis International for obvious reasons. That's where Federal Express is. Louisville International, again, major carrier are there. Miami, for reasons coming from the south, Cincinnati, Los Angeles, Chicago, Ontario, JFK, Indianapolis, Dallas-Fort Worth, Daniel Inouye International in Hawaii, Oakland, Chicago, Atlanta Hartsfield, Seattle Tacoma, Newark Liberty, Philadelphia, George Bush International in Houston, Phoenix Sky Harbor in Arizona, Perot Field, which is a cargo airport in Fort Worth, not to be confused with DFW, Luis Munoz Marine International in San Juan, Puerto Rico, Denver International, and San Francisco International. So those are the locations where a lot of these tariffs were in effect collected. Now, why does that matter? Well, in effect, we know where these tariffs were paid. We know where the records are, which is why this is so important. Now, good news is all this is fairly digital. We can then go to the border crossings where the train came across. Those trains come across every day, all day from Mexico and down from Canada. It's about 27.4% of all value. This is done pursuant to 19 Code of Federal Regulations, Section 123.12, which allows the uninterrupted, in effect, entry of foreign locomotives and equipment for international imports. And they come in mass up from Mexico and down from Canada, delivering about 27.4% of all goods. And there is a tariff that was levied under IEEPA for the vast majority of those goods. And we've got the locations that come across into San Diego, into the Phoenix area through Nogales, El Paso through Juarez. We've got a lot going on in Laredo and Del Rio and Brownsville, major infrastructure rail lines that are importing a lot of goods from Mexico through the so-called maquiladores, or the factories down there that were the results of NAFTA from the 1990s. So the bottom line, whether it's from up top coming down from Canada or down below coming up from Mexico, we know where these rail cars, these intermodal crossings for U.S. imports were coming. Now, why is that important? Well, how can your company work with our firm in recovering the tariffs that were paid by you pursuant to illegal tariffs administered or levied by the Trump administration? Well, here's how. First, you need a lawyer who's licensed before the United States Court of International Trade. This is Rule 74 in 12 pages of glory, but the bottom line is to file a lawsuit in the U.S. Court of International Trade. Your attorney must be licensed there. There are very few attorneys that are licensed. I've gotten licensed there. And why did I do that? Because the United States Supreme Court, in the Supreme Court decision on February the 20th, answered a second question that was before it. Not only was the IEEPA tariff illegal, but what is the court of exclusive jurisdiction? And all disputes with respect to IEEPA tariffs by order of the United States Supreme Court must be filed and must be claimed in the United States Court of International Trade. This is a building that's in New York City. I've been there. And so it looks like IEEPA refunds are going to be easy, but with the tariff struck down, now the fight begins, and we're here to help you through that fight. We spent a lot of time, a lot of energy, a lot of money getting ready for this fight, because there are hundreds of thousands of importers that simply need to get their money back. Need to get the money back for reasons of lowering prices to consumers, to paying staff members who were laid off. A lot of people went under, and we here at the Watts Law Firm are ready, willing, and able to do that fight for you. If you want more information about how your company can work with our firm in the tariff recovery litigation, you can go to our website, which the bottom line is under my law firm, www.wattstrialfirm.com. You can go to the section dealing with tariffs, or you can just type in tariffslawsuit.com and you'll find it that way as well. Now, what are the case-specific requirements for you to participate in the IEEPA tariff recovery litigation? First, you must be filing for a U.S. registered business, either a limited liability corporation, a partnership, a sole proprietorship, etc., but you must be U.S. based in order to pay these tariffs. You must have been an importer of record and paid IEEPA tariffs directly to the U.S. Customs and Border Protection, which is CBP. Those paid tariffs imposed by IEEPA executive orders occurred between February of 2025 and February 24 of 2026. So tariffs paid previous to that are not part of this litigation. You must be able to identify and document the IEEPA duties paid with one or more of the following types of documentation: the custom entry records, or the import broker statements that will show the amount of the tariff that was paid under what statute. Much of this is automated through the U.S. Customs and Border Protection, CBP, Automated Commercial Environment, or ACE records. And so you have, if you've paid this kind of IEPA tariff, what's known as an ACE entry number. This ACE number in a digital world will tell us how much you've paid. So even though you're going to send me the records about what you think you paid, that ACE number is going to allow me to verify that and allow the government to verify it before they ultimately will decide what needs to be paid if ordered by the court. In order to make this worth everybody's time, we have a minimum threshold that the tariff amount paid must be $50,000 or greater. And then we have exclusionary criteria where if you meet one of these, for the good of the whole, we're just not taking these folks on as clients. Number one, if a client can't produce a valid Social Security number or a U.S. taxpayer ID number, a so-called TIN, we don't believe that's a case that we can bring. Second, if you're already represented by an attorney that you've hired for the IEPA tariff recovery litigation, my law firm doesn't look to poach clients from other folks, and we won't be doing that if you already have a lawyer for purposes of this IEPA tariff recovery litigation. Third, a lot of folks paid tariffs under steel and aluminum imports. Steel and aluminum tariffs were done under Section 232, which has not been found to be illegal. So with respect to the tariffs paid on steel and aluminum, we're going to take a pass on that unless you can specifically show us that the IEPA tariffs somehow were implicated. Lastly, our firm has quality control requirements that we require each of our clients to make, to pass in order to become involved in our litigations. Number one, if you can't pass the Watts Law Firm identity verification process, you won't be our client. If you have a criminal history of either identity theft or financial fraud, for the good of those that don't, we won't be pursuing those cases. And then, so what does this fee agreement look like for IEPA tariff recovery litigation? We have a sliding scale arrangement based on the amount of the tariff that we recover for you. It'll be a percentage or a so-called contingency fee. The good news is the money that we spend, the time that we spend, you don't pay us by the hour. We only get paid if we collect for you, and that will be a percentage of the total fee charged. It's higher for smaller amounts. Between $50,000 and $5 million, we would charge 1/3. Between $5 million and $10 million, we would charge 25%. And any amounts over $10 million, we would charge 20%, because the work will in large part be the same, so we can afford to charge less for greater amounts of money. And so that's the fee structure. If you have a lawyer who brings you to us, we do what's called fee splits or referral agreements. There's two different ways this is done. If you were, in effect, made aware of our effort through marketing through a third party, we'll pay that marketing law firm 10%. The person paying for that marketing, another 40%. And then for litigating the case and handling the claim, we'll take 50% of the fee. With respect to direct referrals that don't involve a marketing firm, that 10% wouldn't be involved. And so if your general counsel's office or your referral lawyer brings you to us, we'll pay 50% of the fee to them and keep 50% for our work. Now, this is all very complex. Companies, general counsels, lawyers, importers have questions and answers, and we want to get you all of the answers to all of your questions in order to get you the information that you need. In order to do that, we're going to start off with what I call frequently asked questions. And since we've gotten involved in this litigation, there have been 12 FAQs, or frequently asked questions, that have just come back over and over again. So I've just put them into this PowerPoint so we can get them answered before we begin the specific questions and answers that each of you may have. First, there are large firms that are doing this on an hourly basis. Why should you do it on a contingency fee basis? Well, those large firms typically work for the largest importers in the world, and they're kind of on the payroll. But many smaller importers cannot afford to pay lawyers over $1,000 an hour for contested litigation that you don't know it's going to work out. There's just too much risk. And so what we do is we work on a contingency fee. You don't pay me until we win. Unless we win, there is no fee whatsoever, and we'll cover the costs up front to take care of this litigation. That's one of the reasons that you should do this on a contingency fee. If your particular corporation is of the size and the tariffs that it just wouldn't be economically efficient for you to do this on your own. Secondly, what's the opportunity for my firm and our co-counsel? What will my role be? Well, this is very typical. You have people who know the client, who are not engaged, not licensed before this court, don't have this specialty, so they refer, and we call them co-counsel. So Watts Law Firm, or WLF, will pay its co-counsel up to 50% of the fee that the client pays for clients brought to Watts Law Firm. This is very typical in the industry. Now, once those cases are brought in, what is our exact legal strategy? Well, we do what's called mass tort litigation. Oftentimes we represent 50, sometimes 60, 70,000 people at once in similar litigation. We'll do that here. We'll file lawsuits for each and every one of our clients early and often. We'll engage with the Court of International Trade, the so-called CIT, and hopefully, together with other fine lawyers, we'll force a resolution from this administration that does not want to resolve it, and we'll get those payment of the IEEPA tariffs paid quickly. That's our goal. That's the legal strategy. Will this be a class action? Well, right now it doesn't look like it because there have already been more than 2,500 separate IEEPA refund lawsuits filed in the U.S. Court of International Trade, or the so-called CIT. We're going to file a lot of them. Why is this litigation and not just administration of a settlement? Because you don't have settlements until the defendant agrees to pay, and they're not doing that. President Trump has said he will spend years in the court before repaying these tariffs. We, together with other good lawyers and persistent litigation, hope to change his mind about that sooner rather than later. Our judge has already indicated that this process will be streamlined. And so we get asked the question, why do contingency lawyers need to get involved? Every mass tort I've been involved in has what's called an MDL, or a multi-district litigation, where you get that streamlining that try to get efficiently, but often they take years. And so during those years, do you want to be paying hourly bills to lawyers charging you over $1,000 an hour? Or do you want to reserve those payments where it doesn't come out of your company's bottom line to participate in this litigation, and your lawyers only get paid if we win? That's the difference between hourly and contingency. Some people would prefer hourly. Many just can't do that and would prefer, look, I don't want to pay a lawyer unless they win. Number 7, will Watts represent individuals who lost money from companies that pushed through or pushed down the tariffs? We're doing that research right now, and we hope to answer this yes. We're not there yet because the Supreme Court decision just says that the importer of record that paid the tariff is the party that, in effect has standing to bring the claim. But a lot of that will depend on the individual contracts between the importer who physically paid the tariff and the company to whom they passed along the increased costs vis-a-vis the tariff. Number 8, will there be a line of cases for a company that went belly up because of tariffs? And is that a real opportunity? Look, the bottom line, again, I don't want this to be political, but those against these tariffs have said tariffs are very inflationary. They raise costs. They cost people jobs. Companies were lost. We're investigating this very issue for that reason, and we hope the answer will be yes. We're not there yet, but we are steadfast in our desire to help everybody that was adversely impacted by these illegal tariffs. I've been asked by a hedge fund, why would they just sell their claim to us? The problem with selling a claim to a hedge fund, when it's early in litigation, they command massive discounts until the litigation is over and is in so-called the settlement phase. Those claims have been ordered or agreed to be paid by an affirmed court decision. Just because you win in the lower court, as you saw with the underlying litigation, it went to the Federal Court of Appeals, back to the Supreme Court. This president has a history in litigation of using the courts to buy time. And so we believe this could be a lengthy process. We hope not. But the bottom line is, until an order by a court that is affirmed, these payments are not going to happen. Until a settlement is coerced in effect or required, these payments are not going to happen. And therefore, until then, hedge funds will not give you the value of what you're entitled to because of the risk involved. Number 10. What's the expected timeline to the recovery of these tariffs? If it's administrative or if it's in litigation, well, litigation generally leads to a settlement administration if we're successful. But I looked it up, and the average Court of International Trade length for a case is approximately 16 to 18 months. We do have an excellent judge here, and we hope to expedite that timeline, but we can't promise that. Number 11, what's the expected timeline to the recovery of the tariffs? Again, same answer, but the bottom line is that President Trump is going to delay it for the duration of the term unless the refund is forced. At least that was what he's politically said. Number 12, what do we think the average tariff client's refund amount is? Well, an average is just taking the total amount paid by the number of companies that have paid them. If you do that average, is $166 billion that was paid. It's more than that, I think. There were approximately 330,000 importers, slightly more than that. If you divide the two, on average, Each of these claims is $503,000 a piece on average. Some are much larger, some are much smaller, which is why we're taking claims. If they're at least $50,000, we'll take ones that are much larger, obviously at a different fee structure. For more information, go to our website, which is either at https://www.wattstrialfirm.com/tariffs-lawsuit/ or let's just make it easier. Go to tariffslawsuit.com. Both will direct you to our site, which will have much more information that you can utilize to study whether this is something you want to be involved in. We here at Watts Law Firm, and me specifically, are ready, willing, and able to help you with the tariff recovery litigation, to help you, your importer clients, your lawyers, your general counsels, anybody affected who had to pay these IEEPA tariffs that were illegally levied, totaling $166 billion. We're here at the ready. We're ready to go get that money back for you. Thank you for participating in this video.